Law Talk with Nick Maruchak, thanks to MKI Legal, your trusted employment and family lawyers.
I fought the law and the law won. I fought the law and the law won.
Okie dokie, it's 25 minutes to 11, 1338 882. If you'd like to speak to Nick Maruchak from MKI Legal right here, right now, to take your calls. Hello, good morning to you, Nick.
Good morning, Gary.
How have you been? All right, everything tickety-boo?
I've been great, mate.
Excellent.
Life's been good.
That's good.
How have you been?
Oh, no, yeah, up and down.
Hey, congratulations for the award.
Oh, thanks for that.
Yeah, that was really great.
Yeah, I had a thrilling weekend, with the ACRA Award. It was for the podcast series that we did, as people know, and it was a wonderful time.
And you beat Kyle and Jackie O, right?
I beat Kyle and Jackie O. It's funny how many people have said, I'm so glad you beat Kyle and Jackie O. There's something about Kyle, isn't there, that polarises a lot of people quite clearly. So so there was a relief about that one. But anyway, I didn't, I had no idea when I went over there. I had no idea whether I was winning or losing or whether I was just going to, drown my sorries or whatever the case may be. But there you go. We had a win. We'll take the wins when they come our way. Now, we're going to get down to it. We've got some people on the line. But if you want to speak to Nick, 1338 882, don't hesitate to give us a call now. Elizabeth's there. How can we help you, Elizabeth?
Hi, how are you?
Good.
I just have a question regarding parental rights and specifically my son's father who has just got out, released from incarceration. He was incarcerated for 3 years for domestic violence and then some quite petty charges, all related to drug use. We don't have contact with him and he hasn't had contact with my son, who's 5 now, since he was about 6 months old. But periodically his family pop their head up. And my question is in terms of, say, if I passed on, and is there anything I can put in place to sort of supersede his parental rights in terms of who gets custody of my child? And can I allocate a guardian to my son?
In a will? You mean in a will setting? Is that what we're talking about, just to be clear on that?
Well, no, in terms of if his dad decided that he wanted to have custody of Levi,
right.
Is there, what can I do to sort of override that, or what are his parental rights?
Okay.
Can he kind of just swoop in and decide that he wants to, if I pass on this, is if he wants to pluck Levi?
Okay, well, what we'll try and do is not use names. I'm afraid we'll try not to do that. But I'm going to just, I'd rather we just now let Nick try to answer your question without, so just have a listen to what Nick's got to say.
Just a few things, Elizabeth. Yeah, so I'm sorry you're going through that. It is a difficult situation. So the father of your child, who's currently 5, so is there any court order in place at the moment from the family court?
There's nothing in place.
Okay, so at some point in the future, if he wakes up one day and goes, I want a relationship with your son, then he can reach out and start the process. And the process would be normally he would make contact with you and to see if you guys can reach some sort of an agreement. And if he can't, then you'll go through family dispute resolution process, which is usually done by places like Anglicare or Relationships Australia. So the court will try and get you both to try and see if you can resolve it. If that doesn't work, it goes to the family court, and the family court will make a decision on what's in the best interest of the child. And if there was violence, was your child exposed to violence in the past?
No, he wasn't.
Okay, but did he witness the violence though? Because that could also is taken into account by the court. Child shouldn't witness violence against their parents.
No.
Okay. So the court will make a decision on that violence will be taken into account in any event, and they'll make a decision on what is best for Levi. And it sounds like you've got primary responsibility in this case. So I'm leaning towards the status quo will probably be maintained. And if he does get some sort of rights, it would be in a staged process. So if there was violence, something they do is a supervised visit first, where you can go and either an organisation, you drop the child off at organisation and they monitor him and see how it goes. That's probably the best way. And you do that for a little bit, and then maybe he'll get a little bit more time as it passes.
Okay, just as well, I'll ask you, but again, I'm just going to ask both not to refer to names if I can. Can I just ask, on the basis of a will, is there anything you can put into a will, Nick, that hands guardianship to someone without the father having a right to challenge that and therefore, seek custody?
Yeah.
Is there anything you can do around that? And again, I'll just ask you not to refer to names.
Yeah. So, yes, having a will and saying, if I pass away, this is the person I nominate as guardian for my child, and also maybe, in a separate document, not attached to the will, setting out some grounds and signing it on a stat deck to say all the reasons why the father of your child shouldn't have custody is a good idea. That's not absolutely binding. At the end of the day, the family court will make a decision. So if you pass away, they'll take your wishes into account, and then the guardian that you've nominated will apply to family court to get that parental rights.
Right.
And if he challenges it, then there'll be a decision made. But if he never challenges it, never steps into the picture, then it's likely that it will pass on to the person you nominated the will. So whoever's in your will has a lot of weight. So you should do that.
And also, I would just say that the caller should probably go and sit down and get some, real hard and fast legal advice. And I'm sure you're happy at MKI Legal, if you're still listening to that, MKI Legal to help with firmer way of dealing with that, because it's a tricky one.
Yep.
Thanks very much for the call. We're going to go to Darren. G'day, Darren. How can we help, mate?
Yeah, g'day, Gary. I just got a query. 12 months ago, had a traffic incident on the Mitchell Freeway heading south. There was peak hour traffic. I've had a car come down the passenger side, the outside lane. So he's crossed the solid white line as if we were heading south through the city, and then tried to squeeze in front of a car in front of me, and then jumped on the brakes, and I've just tapped his back end. I'm just wondering, because I've just received a letter from the insurance company asking for payment of a pretty substantial figure. I'm just wondering what the legal grounds are there, as what I believe is he's crossed the solid white line and broken the road rules.
Yeah. So if he's crossed the solid white line, it sounds like he's at fault, right? He shouldn't have crossed that. Sounds like you're the innocent person, and you did everything reasonable because he just got right in front of you and you put on the brakes as soon as you can, but you couldn't avoid hitting him, right? So
Correct. Yep.
So there might be a little argument about whether. So sometimes if you bump into someone, insurance companies say you're at fault because you should have kept a reasonable distance here. But in this case, he crossed the line and really collided into you. So this is the insurance company for him. It's not your insurance company
correct.
denying your claim.
No, correct.
Okay.
No, correct.
So you'll just write back
There was no damage to my vehicle, and I believe because we were travelling at probably 10 kilometres an hour. We're in peak hour traffic, afternoon traffic. So there was not even a car distance between me and the car in front. So as soon as he's pulled in on a 45-degree angle, my passenger side front has just touched his driver's side back.
Yeah.
So,
and what damage, roughly, ballpark cost?
I've now got a letter from their insurance company for just over $4,000.
$4,000. Okay. So you write back to them and you set out your grounds to say you're not at fault, because what the insurance company does is he'll make a claim to them and they will try to recover their losses from the person they think is at fault. So when you deal with the insurance company, you're basically dealing with someone who's in just normal litigation matters. So you'd write back to them and you give them all the reasons why you're not at fault and he is, and then the next step will be they might accept it and not pursue it and just pay it out. Or if they take it a little bit more seriously, they'll probably commence a claim on his behalf in the magistrate's court. It's a claim under $10,000, so there's no cost risk to you. And look, it might affect your credit record if there's a judgment, but generally when these claims are commenced, you go to a mediation stage and you can resolve it. But the insurance company may not go to that hassle. And at this stage, this is the first contact, so they're really just finding out your story, and then they're going to make an assessment whether who they believe.
Hey, Darren, just quickly, was it like a stop situation where you both have a chat and change details?
No,
it's nothing
it
like
wasn't,
that.
Gary.
Okay, sorry.
No, he's actually jumped out and quickly taken a few photos. I didn't want a chance jumping out the car in case someone come around the outside and took off the door or hit one of us, you know.
Right.
So it was just at the entrance to where the Graham Farmer splits off left.
Yep.
You can go straight forward to go down Jameson Road, or you continue right to go through the city and then to the south of Perth.
Yep. I know exactly where it is. And so there was no moment where he said, "Oh, sorry, mate, I did that," or?
No, he just come down the outside and then tried to quickly swing into a gap which wasn't there, you know.
All right. Well, it sounds like you just go back and say, look, I'm not at fault in this, and therefore they're going to have to take it much further if they're going to want to prove it. Hey, Darren, thanks for the call. We'll come back. Daryl is on the other side. I think we've got Benjamin as well. Stick with us, folks. We won't be long. If you'd like to speak to Nick Maruchak, MKI Legal, you can still call. I think we've got some time. 133 882. Get on the lines now.
Law Talk with Nick Maruchak. Thanks to MKI Legal, your trusted employment and family lawyers.
Okay, we're going to go to Benjamin straight away. He's got a bit of a situation which he'll need to explain to us. G'day, Benjamin. What's happening?
Good morning, Nick and Gary. Look, I have a bit of a situation with my super fund at the moment. So I was terminated from my employer during probation. Given a week's notice, given payment in lieu of notice, which is all lawful given it's a small business under 15 employees. I've subsequently gone into a very tight job market with about between 15 to 20 applications currently in the works to find work. I've got a young family, 3 young kids, and I said, I need some short-term relief, so I'll try and tap into a percentage of my superannuation. Based on compassionate grounds. Now, I'm in my mid-30s. I've got nearly $250,000 in super, which is probably at the top echelon for sort of my age group. I said to the super company, they said, you need to reach out to the ATO. The ATO's knocked it back because it's not a foreclosure on my house. I'm not totally disabled or I haven't lost a loved one. You need to go back to your super company. The super company have said, look, in order to be eligible, first of all, you need to be on Centrelink for 6 months before we even consider it. Now, it is ridiculous to say the least that I want to access probably, let's say, between $10,000 to $20,000 based on compassionate grounds, which were the same grounds, and rightly so, that the super company released the legislation back during the pandemic for people to access their super early to support their lives. And some people took advantage of it and bought dogs and jet skis and other holidays and other bits and pieces. Whereas I'm just saying, look, I don't want anything above normal. I just want what people have previously accessed.
Oh, wow. It sounds reasonable, but is he able to argue out of that? I mean, he's going to be a taxpayer burden by going to Centrelink as opposed to going to his own pool of money.
So in your case, you need to be on Centrelink for 26 weeks and you cannot meet your reasonable living expenses. So the super fund won't be able to release the money unless you meet those 2 criteria. And if they do release the money, because super funds have got in trouble for releasing funds early if they don't take adequate precautions to make sure that this is a last resort. So, and this is not, if this was in relation to a house and your house is being foreclosed, then you can go to the ATO and then you can get funds to stop the foreclosure. But this doesn't apply to a house, right? So that's the difference in your case. It's just unrelated to property. Yes. So it's pretty strict. It just says 26 weeks and that's the minimum. So I think they're right there. Now, there's just a few other circumstances where if it's a medical grounds or you need money for medical care or someone's passed away or even renovating your house because of medical conditions, you can do that, right?
Yep.
But so all these other grounds apply that may apply to some other people, don't apply to you. So, and then look, if someone's in this situation, you can go to AFCA, right? So if a super fund knocks you back and you think they should have released the money, you go to Australian Financial Complaints Authority and they can deal with it. But in your case, I'm looking and I'm going, you have to do the 26 weeks of Centrelink. And I can't think of anything else right now which you're entitled to release it. The only thing I say is you can get a financial, like like a financial coach. So if you go to like the government money website, right, you type that in and you get someone that can help you with if you're in a financial counselling, right? So a financial counsellor can come in and like the Money Smart government website, you search for that, you find a financial counsellor service, and they will be able to kind of help you out. I would recommend that as a next step.
But it sounds like, mate, you've just exposed a bit of a stupid situation, Benjamin, and I appreciate you doing that. But letter of the law makes it hard for anything to happen until that 26 weeks is up.
It does, and I've lodged a complaint with AFCA, and I've also gone to the local member, Josh Wilson, the federal member, because, against Gary's point, they would rather me sit on government welfare than access money that technically is my money, and it's no good to me in 30 years' time if I'm homeless and can't put food on the table for my kids.
Bloody hell, that's very interesting.
That's right, and maybe like if you've got a good amount of super, so there should be a test there. If you reach a certain threshold for your age, just the balance should be able to be accessed.
It's called common sense, Nick. Sometimes the law is an ass and common sense should win every time. But Benjamin, I do appreciate you bringing it to our attention, even though we can't really do much for you. Darryl's on the line. G'day, Darryl.
Yeah, g'day, Gary. And Nick, mine's probably a little bit simpler of a question. Yep. My mother has a will, and she's 86 years of age, but the will was done about 7 years ago, and the address that she is currently living in now is not the same address that's on the will. Should we get that changed?
Oh, it's you don't need to. So when you make an application for probate, what you do is you say the mother's name of the current address, formerly of the former address. So that's what always is on the application, your current and your former address. So you don't need to. The will's still valid 100%. And when you make the application, you just mention the old address and the new address. So, you don't need to. You can if you want, but I wouldn't. It happens all the time.
Okay. Does that help you, Darryl?
Address. Yeah, no, that's good. Thank you. I don't need to change anything. Thank you.
All right, mate. Well done. Nick Maruchak, thank you very much for coming in and sharing your knowledge with us. I think the Benjamin's probably the caller of the day in terms of, isn't that one of those just stupid situations where government trip over themselves with red tape and bureaucracy as opposed to just say, he's got that money sitting there. Let's let him access 20,000 of it.
Exactly.
So, all right. Something to look at. Maybe a legislator, an MP, will drive that one through to make changes to it. Okay, that's Nick Maruchak from MKI Legal. Right now it's coming up to 4 minutes to 11.